So hello guys, this is part 2 of the Hindu Marriage Act 1955 and our next point is section 12 voidable marriage. A marriage is voidable on either side of the party is known as voidable marriage. It will be valid unless the petition for invalidating the marriage is made. The marriage is to be declared void by a competent court under the Hindu Marriage Act 1955. And section 13 says presents the general ground of divorce that are available to both the parties involved in a broken marriage. Clause 1 of A, introduced in the Act of 1955 by the Hindu Marriage Amendment Act 1964, provides to further grounds for obtaining a divorce decree. Clause 2 of Section 13 specially provides four grounds that can be availed for getting a divorce only by the wife. Divorce grounds can be viewed from two perspectives. Number one is marriage is an exclusive relationship, and if it is not, it is no longer considered marriage. Marriage also indicates that the parties would live in a peace and trust with one another. Cruelty or threat of cruelty undercuts this fundamental condition of marriage. The essential premise of marriage is that both parties will live together. However, if one party abandons the other, this premise is no longer valid. As a result, infidelity, abuse, and abandonment are all detrimental to a marriage's basis. And second point is, from a different perspective, the above acts are martial offences committed by one of the marriage partners. There is a semblance of crime here. Divorce is viewed in this light as a means of punishing the partner who has proved himself or herself unworthy of association. The guilt or offense theory of divorce, which states that the offense must be one that is recognized as a basis for divorce, is a consequence of the discussed perception. Section 14 says, according to this section, a couple cannot register a petition for divorce within a year of marriage. However, if the High Court feels that the petitioner is experiencing immense problem, then High Court can permit them to file for divorce. Section 15 of Hindu Marriage Act 1955 states that after a valid divorce, either party is eligible to remarry. And section 16 of Hindu Marriage Act says about the children of a void marriage are deemed to be legitimate but only if certain conditions are satisfied. The section also deals with voidable marriages, but we are not concerned with those marriages as the section stands now, where a decree of nullity is granted in respect of any marriage under section 11. For example, in respect of a void marriage, any child begotten or conceived before the decree is made who would have been the legitimate child of the parties to the marriage, if the marriage had been dissolved instead of having been declared null and void, shall be deemed to be their legitimate child, notwithstanding a decree of nullity. And section 17 says about punishment of bigamy. Any marriage between two Hindus solemnized after the commencement of this act is void if at the date of such marriage either party had a husband or wife living. And section 18 says every person who procures a marriage of himself or herself to be solemnized under this act in contravention of the conditions specified in clause 3rd, 4th, 5th of section 5th shall be punishable. In the case of a contravention of the condition specified in clause 3rd of section 5th with rigorous imprisonment which may extend to 2 years or with fine which may extend to 1 lakh rupees or with both. In the case of contravention of the condition specified in clause 5th or clause 4th of a section 5th with simple imprisonment which may extend to 1 month or with fine which may extend to 1000 rupees or with both. Section 19 says every petition under this act shall be presented to the district court within the local limits of whose ordinary original civil jurisdiction, the marriage was solemnized or the respondent at the time of presentation of the petition resides or the parties to the marriage last resided together, or in the case the wife is the petitioner where she is residing on the date of presentation of the petition. And section 20 says about contents and verification of petition. Every petition presented under this act shall stated as distinctly as the nature of the case permits the fact on which the claim to relief is founded. And except in a petition under section 11 shall also state that there is no collusion between the petitioner and the other party to the marriage. The statement contained in every petition under this act shall be verified by the petitioner or some other competent person in the manner required by law for the verification of plans and may at the hearing be referred to as evidence. And section 21 says about subject to the other provisions contained in this act and to such rules as the High Court may make in this behalf. All proceedings under this act shall be regulated as far as may be by the Code of Civil Procedure 1908. Section 22 says every proceeding under this act shall be conducted in camera, and it shall not be lawful for any person to print or publish any matter in relation to any such proceeding except a judgment of the High Court or the Supreme Court, printed or published with the previous permission of the court. If any person prints or publishes any matter in contravention of the provisions contained in subsection 1, he shall be punishable with the fine which may extend to 1000 rupees. And section 23, which says there is no other legal ground why relief should not be granted then and in such a case but not otherwise, the court shall decree such relief accordingly. And section 24 of Hindu Marriage Act 1955 defines the provision of maintenance pendent life and for expenses of legal proceedings of a divorce. And section 25 defines the complete provision of the permanent alimony and maintenance for the alliance under this act. Section 26 defines the provision for custody, maintenance and education of minor children during and after legal proceedings of divorce. So guys, this is part 2 and part 3 will coming soon. Thank you.